Just a short introduction. I'm David Hollop. I'm a counselor at the PACE Business Development Center. PACE is a nonprofit community development organization based in LA. We provide comprehensive community development services that promote sustainable economic mobility for underserved communities. We have several core programs, including early childhood education, energy efficiency, housing, workforce development, and our Business Development Center, which I'm a part of. And through our Business Development Center, we support entrepreneurs in Southern California by offering business counseling, procurement services and assistance, and access to capital. The city of LA has 10 BusinessSource Centers, and PACE operates two of them, one in Pico-Union near downtown LA and one in Hollywood, where I'm based. We are an SBA microlender, an EDA and iBank lender, and we are also a certified CDFI. Today's workshop is part of the Small Business Legal Essentials webinar series presented by Public Counsel, and today's topic is contracts. There will be one more workshop on May 27th covering intellectual property. This workshop is being recorded and will be available in a few days on our e-library, which you can find on our website under the Workshops tab. I'll put a link in the chat to the e-library. We will have a Q&A session after the presentation, and you can also use the chat box to submit your questions along the way. When you exit the workshop, there is a brief survey. If you could please complete that, it helps us understand what works and what doesn't, and other feedback on this workshop and others you would like to see. I see there's an echo. Sorry about that. I will mute my mic in a minute. Hopefully that helps. I'll let Kavitha and Courtney introduce themselves in the roles of public counsel. So with that, I will turn it over to Kavitha to start the workshop. Thank you very much.
Okay. Hi everyone. So I'm Kavitha and Courtney's also on the line. My camera is not working at the moment. I apologize. I might get it started at some point. So just a disclaimer, let me see if I can work this. I'm sorry. We're having a little bit of technical difficulties, but we will get through this. Okay, so I'll have to read it off another slide because I'm not able to go back for some reason. Give me 1 second. Let me see if I could. Oh, previous. Okay. Okay, so obviously today we're going to be talking about negotiating and drafting contracts. Why is this not working? This is so crazy. Sorry, Courtney, how do I go to the next slide? It keeps taking me. Okay, it seems to be somewhat working now. Okay, so this is part of the small business legal aid program. So what it was is like during COVID, obviously a lot of businesses were affected, and some extra money that the state had and the county had, they decided to spend it on legal services for all of you. So I know a lot of you guys have, small businesses, and so we're here to help you with a lot of different types of legal assistance. And so, if you ever have an issue, like a legal issue that comes up, whether it's employment or contract, or someone slips and falls at your business, or you're being sued for something regarding, maybe disability access or anything, you can at least ask us because probably we can provide you at least the basic information without charge. And we never charge a public counsel. So it would probably save you a lot of money to start with calling us first. And if for some reason it's pretty complex or we can't go to court with you, then we'll just let you know. But we may even be able to find you like a pro bono attorney. So some of the things that we do, as you can see on the screen, we will draft and review your contracts. This could be any type of contract. So like, even if you have, you have a business where you're showing tourists around and you want them to sign a waiver, we can look at that contract. It could be a contract with, an employee. It could be like something related to IP or trademarks. We do the choice of entity, like should you get an LLC or should you be an S corporation or sole proprietorship? Employment law advice, like we have somebody right now who decided that, 5 of their employees were going to take off at the same time. He was really mad and he wants to fire all of them together. So we need to talk to him about whether that's a good idea or if they may do a lawsuit against him. Um, we can help you with like negotiating debt. So sometimes, maybe business takes a downturn. You're not able to pay your landlord the rent for a few months and now they're suing you. Well, maybe we can say, look, this is a nice guy. He doesn't have much money. Let's work out a deal, right? Do you really want to go to court against this guy? And sometimes we're able to work out a pretty reasonable deal with the other side. It could also be credit card debt, a bunch of stuff that we can help you with. We also help childcare providers, like if you have kids that you look after. Sometimes they have legal issues that we help them with, and then issues related to websites. Um, so we do a bunch of like legal things that we can help you with.
And Kavita, I'm not sure if the slides are actually advancing
Oh, they're
visibly
not.
to people.
Okay. See if I can. Should I stop the share and see if that?
Maybe, and
Can you see this one or
yes.
did it just change?
Hmm.
Oh, okay. So maybe it was on the wrong screen. Okay, fine. So let's see. We were on what is happening? Okay, sorry, Courtney. You're gonna have to
That's
switch over
okay.
because it froze for me. I
Sure,
mean,
I might be able to share them if it's easier for you.
yes. Okay, let me see if I can stop the share on mine. Okay.
Okay.
You can do the rest of the slides, I guess, to
Okay.
19, and then thank you.
And let's see. Can people let me know if they see the slides?
Yes, I do.
Okay. So just as a disclaimer, this presentation is intended as a general overview of negotiating and drafting contracts, so it does not create any lawyer-client relationship and should not be construed as the provision of legal services to any individual or entity. And so you can make sure to consult with an attorney regarding any specific questions you might have that pertain to your specific business. And so Kavita explained this slide. And here's just how to contact us to apply for our services. Here's the link as well as the number. And I will just I'll give you all a moment to just write down either or both, and then we can send them in the chat at some point during this presentation as well. Okay. So Kavita has kind of explained sort of the services that we will offer. And so we can move into our main topic for today, which is contract drafting and negotiation. So first, here's an overview of the topics that we'll be discussing today. So what is a contract? When is a contract formed? When should a contract be in writing? What is the Uniform Commercial Code and when does it apply? What terms should a contract contain? When will a contract not be enforced? When is a contract breached? What should you do if your contract is breached? And what remedies should you be able to recover in case of breach? Okay, so first, what is a contract? A contract is a legally enforceable agreement to do or not do a certain thing or set of things. So it's legally defined as a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law recognizes a duty. So all contracts involve three components: an offer first, acceptance, and what's called consideration. So I'll go into more detail about all of these elements in a moment, but essentially, someone needs to offer something to someone else. And then the other person accepts that offer, and both parties will be exchanging something of value as part of the agreement, which is called consideration. So to go into a little bit more detail, reviewing the elements of the contract that I just discussed. First, offer. An offer is a communication to a specific person of a contractual intent to be bound by certain and definite terms. So this just means that an offer is a proposal by one party to enter into a binding agreement. And that offer needs to be specific enough so that a reasonable person could understand what rights and obligations they have if they were to accept that offer. And second, acceptance is defined as a manifestation of assent to the terms of the offer that are communicated to the offeree after the offer has been made. And so this occurs when the other party demonstrates that they are entering into the contract and agree to the contract's terms. And then finally, consideration is defined as the bargain for exchange of something of value. And this exchange involves both people giving something up to the other person. And it's important to note that a promise to make a gift actually is not considered consideration. So you cannot promise to make a gift and have that be an enforceable contract. And so now that we've defined these general terms, it might be easier to contextualize them in the example of selling a basketball to a friend. So let's say you offer to sell your basketball to a friend for $20. This is the offer element where you propose the terms of the sale. Then your friend agrees to buy the basketball for that $20 fee, and that's your friend's acceptance of your offer. And your friend can communicate that acceptance verbally, or they could communicate it in writing or through an action that clearly indicates that they want to be a part of this agreement. And the consideration here would both be the $20 that your friend is paying you and the basketball that you're giving up in exchange. So again, consideration is something of value that the parties exchange as part of the agreement. And so clearly here, you and your friend both have the intent to create an agreement with one another. So that means that you have a legally binding agreement. You need there to be what's called a meeting of the mind. So both parties intend to be bound by the agreement. And it's also important to have legal capacity to enter into an agreement. So if you're younger than 18, for example, you are not considered to have legal capacity to enter into an agreement. You also need to have the mental capability to enter into an agreement. And finally, you can't do something, you can't contract to do something that would be against the law. Clearly, in this case, though, selling a basketball is a legal transaction. Oops, not seeing. Okay, so certain contracts must actually be in writing to be enforceable to satisfy what's called the statute of frauds, which is just a legal principle. And here you can see the types of contracts that need to be in writing, and they actually spell out a helpful acronym, my legs. So first, marriage contracts. The second is the Y is year contracts, so agreements that cannot be performed or completed within 1 year. L for contracts for land or real estate, so a contract to buy a house, for example. Then we have E, executors promise to pay the debts of a person's estate. G, contracts for the sale of goods, of at least $500. And then S, surety contracts, so contracts that guarantee to pay someone's debts. So if you have one of these types of contracts, you have to have it in writing to be enforceable. But it's always, important to try to make sure that any contract that you write is in writing. But technically, other types of contracts could be formed orally. And so in addition to this acronym of my legs, in California specifically, there are a few other types of contracts that need to be in writing. So if the person who's making the offer can't complete the agreement's terms during their lifetime, that contract must be in writing. And then agreements to loan, grant, or extend credit in amount greater than $100,000 made by someone in the lending industry, and that loan or grant is not for family or personal or household purposes. So for this next segment of the presentation, just think of the different types of small businesses that you have and what sorts of contracts that you enter into, because we'll be talking about two different bodies of law that govern different types of contracts. So first, some contracts that you'll enter into will be for goods or the sale of goods, and the other type of contract that you could enter into is for services. So goods are defined as tangible items that you can move around, and those do not include real estate or services. So again, goods is separate from services, and services like, for example, washing your car or having a car washing business. And so contracts for goods are governed by what's called the Uniform Commercial Code, while common law is what governs contracts for services. Okay. So even though there are similar principles between each of these bodies of law, there are some technical distinctions that are this important to be aware of. So again, the Uniform Commercial Code outlines the requirements for the sale of goods. So for example, the UCC section 2602 outlines the requirements for an effective rejection of goods. So this will kind of tell you when you're allowed to reject and not pay for goods that you receive if they are not in the condition that the contract agreed to. So let's say you own a restaurant and someone orders 20 individual pepperoni pizzas for a party, but your restaurant sends out 20 medium-sized cheese pizzas without pepperoni instead. So first, and you can just think about this for a moment, would you say that this contract falls under the UCC or common law? And so this contract specifically is under the UCC because it's a contract for the sale of pizzas, and pizzas are tangible, movable items. So that means that the UCC makes the rules for this type of contract and says what the parties have the rights to do in this case. So before the customer can reject and not pay for these cheese pizzas, there are a few steps that customer has to take. First, they need to reject those pizzas within a reasonable time after they're delivered. So a reasonable time would not be to get the pizzas, see that they're cheese instead of pepperoni, and keep them around for several days before deciding to reject them and ask for money back. And then next, the customer would need to tell you, the seller, that they don't want the pizzas, so they have to let you know that something's wrong with the goods. And then finally, the customer has to give you and your restaurant the chance to correct the issues with the pizzas. And so they have to give you the chance to deliver the right pepperoni pizzas that they actually ordered. Okay, so to see what we've learned so far, I'm going to read just a short conversation between an attorney and client. And then if you'd like to put in the chat your answers to these two things or think about them to yourself and answer a couple of questions that I'll have after reading this scenario, please do so. So the scenario, client says, I would like help to draft a contract for my customers. Can you help me? The attorney says, yes, of course. What services do you provide? What do you charge? And how long do you want the contract to be for? The client states that the services are related to providing childcare and that they charge $2,000 per month and the contract will be for 5 years. So first, does this contract have to be in writing? And second, is what law governs? And I'll give just a moment to think about it and then provide the answers. Okay, so the contract does need to be in writing because it cannot be completed within 1 year. As the client stated, they want the contract to be for 5 years. So it's an example of a Y in the My Legs acronym that we went over before, one of the contracts that cannot be completed in just 1 year. Second, the common law would actually determine the rules for this contract because it's a contract to provide services for childcare. So again, the common law governs service contracts and the UCC governs contracts for the sale of goods. So next we'll just talk about some terms that contracts should include to be enforceable. And the terms of the contract usually have to be reasonably sufficient and specific so that both parties understand what rights and obligations they have, and for the court to be able to shape a remedy or a fix if either or both parties breach the contract. So first, we definitely need to know who is contracting and the identity of each of these parties. And then we need to understand what the contract is about, so the subject matter of the contract. And in the examples that we've gone over so far, we've seen contracts where the subject matter is the sale of pizzas and the provision of childcare services, just as examples. And then it'll also need, any contract will also need some specific terms, like the quantity or price terms. Here are some other terms that are important to include. So we have, the dates and the parties, as I was mentioning before, recitals, which just kind of provide the context of the agreement, so the factual background and what the contract's about. Representations and warranties, which are factual statements and guarantees that those statements are actually true. Events of default, so how each party can breach the contract and what does breaking the contract look like. Termination provision, so what situations will end the contract entirely. Remedies, so how parties can be made whole again after a party breaks the contract. And these remedies can include, monetary compensation or having the contract actually completed. Liquidated damages here just means that the parties ahead of time decide that there's a set amount of money that the other party will receive if the other breaks the contract. And then injunctive relief is essentially is another remedy that is either saying that a party is required to complete a part of the contract or needs to stop doing something. And then boilerplate provisions are just these standard parts of the contract that you'll see that are less customized for the specific contract circumstance. And then finally, signatures. So it's critical to have these because signatures bind whoever is the parties to the contract. And so let's say you are entering into a contract on behalf of your LLC. It's important that you sign on behalf of that LLC and not just in your own name in your personal capacity. Here are just some other contract terms. So, the start date, we talked about dates before. You want to know the duration of the contract, those sorts of things, and how to resolve disputes. So we saw on the previous slide, things like arbitration, and you might have heard of arbitration or mediation, or going straight to court. So having a dispute resolution provision in case things go wrong is important to include as well. So another quick application of what we've learned, let's say a small business owner wants to contract for providing life coaching services to customers, or to clients. You can feel free to put your answers in the chat or just think to yourself about what are some terms you think should be included in that contract. And I'll give just a moment again and just provide some suggestions for answers. So some things that we might want to have in this contract include how much does a person have to pay per session? When will the services start and how often will they occur and for how long? So duration type terms, a cancellation policy, and the names of the parties. So who's doing the coaching and who's the client, and some signatures. So those are just some examples of provisions that should be included in this type of contract. And then we'll talk about some defenses to enforceability. And so these are just arguments that people can make to say, hey, this contract isn't valid. It can't be enforced at all. So for example, let's say the contract was entered into by force or coercion, or one party made misrepresentations of facts, or wasn't honest. Or maybe the subject of the contract was illegal. So let's say if the subject of the contract was to commit a crime. Or as I was mentioning earlier, the person who entered into the contract was 16. You can't be under 18 and be able to sign a contract or enter into a contract. Or the person was intoxicated when they made the contract and the other party was aware of that. Another defense actually might be that it's impossible to perform the contract at all. So, for example, let's say there was a storm and that storm destroyed the building where the work was to be performed. So the work can't happen at all anymore. you can't move forward with that contract. And so I'm actually going to pass it over to my colleague Kavita at this time to talk a little bit more about contract defenses and other elements of contracting.
Okay, thank you, Courtney. Yeah, and one idea just back to what Courtney said about like if it was impossible, like if you were trying to maybe you were selling something like a machine or something to like a pizza shop to make pizzas, but now it got destroyed in the fire. Well, then the court will just, basically excuse you based on impossibility. So sometimes there's impossibility, like also during COVID, like where trade was not going through, the ports were stuck. And so sometimes those are like, good legal defenses. I'm sorry, go forward, please. Yeah, and so yeah, I guess that was like the impossibility thing. Like, if the art was destroyed, items were destroyed, then obviously, there's not much you can do. And similarly, like if you were also trying to purchase something and it was destroyed, then you can't really enforce that because how are they going to build it again sometimes? When there's like fraud, obviously that's another defense. Now this one's a little more difficult. Sometimes like this may come up like where I had one case where somebody had marble tiles that they were selling, like in a marble shop. And then when they sold the tiles, they were not, the other party claimed, like, oh, these are not really good quality. And, I think that this is fraud because they should be like this proper certain grade quality. Well, it was kind of hard to show that the person selling the tiles was actually trying to commit fraud. And so fraud is something that's like difficult to usually prove or even allege in a court. You need to have like a more like serious allegation of fraud. Like for example, someone forged a signature, someone stole something, someone selling you, a Van Gogh painting, but it's really fake, like something like that. Next slide, please. Breach and termination. So a breach of the contract is obviously when someone does not abide by the contract, right? It could even be you being a tenant in your apartment and you don't pay the rent. Well, you've just breached the contract, right? So anything that you don't pay Netflix. Well, now you've breached their contract and you no longer will have Netflix next month. So the breach can be material or it can be minor. So like in a material breach, then you're allowed to terminate that contract and stop your performance, right? But you have to make sure that it's not just a minor breach because then if you just cancel the whole thing over a minor breach, then you could be in trouble for breaching it yourself. So this could be an example of like um, let's say like someone, you had an ice cream shop and somebody was supposed to deliver, let's say someone was supposed to deliver you milk, right? Like every week they're supposed to give you like, 20 gallons of milk to make the ice cream. Well, if they were a day late, and you were still in business and it didn't like end your whole business and now you just cancel the contract and you say to the guy, the farmer with the milk, well, I'm not going to pay you. Well, now you could be in trouble because this was minor and you just got the milk a day late. But if they actually stop delivering you milk for weeks, well, now this is like a major, breach, right? And you have to go find another guy or another woman to give you the milk so you can make the ice cream, and you may have to obviously incur extra charges. So it would make sense in that case that you are, the court will allow you to end that contract. And for the minor breach, if you had to wait a day and you lost like $200 in sales, okay, maybe you just get the $200, but you don't get the whole amount back for the whole contract. A waiver is the failure to insist on the contract terms. Okay, so sometimes what happens is like if any of you guys, and also in the chat, you guys can let us know, what kind of businesses do you guys have? Like, do you guys have any like where you're renting a space or is it a website only online business? Is it a restaurant? Like, what kind of business do you guys have? I'm just curious because we might be able to think of examples. So feel free to enter that in the chat. And basically for, let's say for example, you are renting a space and you're going to open maybe like a computer store, right? So you're going to sell laptops. Well, your landlord said in there that you had to have like, five types of insurance, right? He said you have to have workers' comp and you have to have general liability insurance and all this stuff. And so but he kept collecting rent from you for like 2 years. He never asked you about your insurance. Well, if later he goes and tries to end the contract and say, well, you know what? She never had insurance, so she's the one who violated the contract. So actually, you could say, well, the landlord never even asked me about that insurance for 2 or 3 years. So I don't think he really cared, and that's not, he kind of waived that, right? So sometimes the court will say, well, it's not enforceable because it was never enforced. Okay, interesting. Next slide. Okay, so I see the types of businesses, nonprofits, want to start another business, website downloadable, says Elizabeth. Is it meditation or mediation? Meditation, I guess. Um, Nonprofit planning to open an educational program for lower elementary schools, offering enrichment courses. Um, and was this supposed to be on commercial lease contracts? We do have another one, right, Courtney, on commercial leases. We have like another presentation that we do on that. So I'm not sure, maybe David will know, but that may be another day because we often do the commercial lease contract trainings as well. Um, so this one's just generally like contracts, when you're entering a contract with someone. But it could also apply to your commercial lease sometimes in a bit. Okay, meditations. Okay, that's a good thing. We'll all be very peaceful. So examples of minor versus a major breach. So you can terminate, or with a major breach, you're allowed to end the contract, right? Like we talked about before. For example, let's say that, you were supposed to get 100 t-shirts on from at your store on February 15th. Um, or sorry, you received them on February 15th, but they're 5 days after the delivery date. So you told the vendor, you know what, I want these in my store by February 10th. And you get them, but they're 5 days late. So was this a minor breach or a major breach? Now, um, normally that's just considered minor, right? You're not going to go out of business. You're not going to lose a lot of business because the t-shirts came a few days late. But let's say these are like pink shirts or purple, some kind of like pink or red shirts, and they say like Happy Valentine's Day. And now you get them on February 15th, and you're supposed to get them February 10th because you thought all these people are going to come to the store and they're going to buy these shirts. Well, at this point, maybe it is a major breach, right? Because how are you going to sell those shirts now when Valentine's Day is already over? So, you have to it depends on the circumstance. Next, yeah, so Jessica, that's correct. That'd be major. So contract remedies. Damages would be, so there's different type of remedies. Okay, so obviously, you guys are doing different type of businesses. So let's use the one of like meditation. So if someone's doing a meditation and yoga class, right? And they are able to, maybe they're ordering like yoga mats or something and they never come, well then obviously the money can come back to the yoga and meditation center, right? Like you don't have, the vendor needs to pay you back because they never delivered them, right? You've waited a couple months, you never received them. So that would be like a money damage. That's very simple. Now in terms of like a lot of people think like, oh, you know what? You didn't deliver this on time, or you didn't provide me this service on time, and I'm gonna ask you for punitive damages, and I'm gonna like not just get the $2,000 for all these yoga mats. I'm gonna say that you have to pay me an extra 10,000 for punitive damages. Well, it doesn't usually work like that because in most contracts, there's no right to punitive damages. Punitive damages are only allowed if it specifically says in your contract that you're allowed to have punitive damages. So just remember, someone cannot threaten you with punitive damages, and you can't threaten someone with punitive damages in most contract cases, like 90, probably 95, 98% of them, unless it says, oh, you're allowed to get punitive damages. And that really I've only seen in like, maybe you're dealing with like some really big company and like something really like special type of goods or services. So yeah. Now in terms of specific, sometimes the court can also order specific performance where they say like a money is inadequate. So that could be, for example, let's say like you have that ice cream shop, right? And now if the person decided, the vendor or the farmer decides not to give you milk and it's been 2 weeks, well, now let's say you lost $5,000 in sales, right? Because it's summer, everybody's buying ice cream. Well, you could get back the $5,000. Plus, if you had to go to Ralph's and pick up like 30 gallons of milk or whatever, and you had to pay, I don't know how much milk costs anymore, but let's say it costs like $1,000, you have to then they also have to pay you for the $1,000, right? So they have to pay you for that extra cost that you had to pay because they failed to do their part. So now you're getting the 5,000 plus the 1,000 extra cost. You're getting 6,000. Um, Specific performance is more like where money is not enough. So let's say the ice cream shop ordered, some really vintage, beautiful ice cream churner, I don't know, some kind of machine, right? And it's like from 1922 or something. And they knew it was going to be beautiful in the window and everyone's going to come and look at it. And obviously, if you paid $2,000 for that, you just getting the $2,000 back is maybe not enough. Maybe you made your whole ice cream store named Vintage Ice Cream Stores, right? And so you wanted to create this atmosphere. And so now the vendor's like, oh, you know what? We've got some tariffs from China. I don't really think I'm going to send this. It's kind of expensive for me. Well, you could go to court and tell the court, like, this is like a special piece. It's not just, I can't just buy this anywhere. So the court will say, well, okay, you know what? To the vendor, you need to, I don't care if it costs you more or whatever the extra work is, you need to get this ice cream shop, their 1922 model, right? So that's kind of how you think of it. Um, Rescission is where a contract is canceled, the parties are restored to their initial status quo. So usually if there's like a mistake, for example, like both parties are wrong, like maybe they were going to pay, like maybe it's like an antique shop or something and they're gonna sell like some, $1 million painting from some famous painter. And then like you think it's real, so you're gonna pay the $1 million and the guy selling it thinks it's real. But now, maybe some antique person came and looked at the painting and they're like, oh guys, this is actually a fraud. So then in that case, you're allowed to not pay. And the vendor can also say, yeah, I'm not going to sell this like fraud thing, right? So the whole contract is just going to be canceled. So that's usually where there's like a mutual mistake. Um, and then like reformation is if you guys are both mistaken. Like for example, maybe you were trying to buy like those yoga mats and you were gonna buy like, I don't know, like 100 of them for $1,000, but you accidentally put $100. Well, obviously there was probably a mistake with a zero, and the court's gonna let you just go ahead and you guys can both fix that, right? Just rewrite it according to what you guys really thought. Next slide, please. Um, so in terms of testing your knowledge, you want to ask yourself like, is there an enforceable agreement? Um, okay, in scenario one, the customer decides they no longer want your services to deliver cupcakes, and they suddenly stop making the payment. The contract was never written down. So what can you do? Does anybody have any ideas you could put in the chat? No longer want your services. Um, So basically, so if they were supposed to deliver you cupcakes and it was never written down, what can you do? Well, see, that's going to be a little difficult, but maybe you could look at something like maybe you made partial payment to them, right? Maybe you have some text messages to them like, "Hey Jane, I like your red velvet cupcakes, I love if you could drop down 2 dozen, next week." So you could look outside of a contract and see if there's enough information and maybe you Zelle Jane some money, right? And to pay a deposit for the cupcakes. Well, now you've kind of created some evidence of the contract, even though it's not there. But like Courtney mentioned, if it's a certain type of contract, like if it deals with real estate or like services over $500, you're supposed to have it in writing because that's under what's called the statute of frauds. But sometimes the court will still want you guys to be fair and they don't want someone to like get free money or free cupcakes. So they will make sure that, the person is paid something. Scenario two is let's say you want to terminate the contract because the customer is not abiding by the terms and they stop the payment. So you deliver cupcakes every Friday and they haven't paid you for 3 weeks. So then you have to ask yourself, like, okay, what can I do? Right? Um, you guys can put it in the chat or I can just tell you what we could do. Okay, so the first thing you want to ask in every situation is there an agreement, right? And what is the proof of that agreement? So again, do you have a written contract? Do you have text? Do you have a voicemail? I mean, do you have something, right? Usually it has to be documented. So voicemails are not always admissible, but something in writing, email or text would be. And has there been a breach? Because yeah, I've been delivering cupcakes and they haven't paid. Actually, this happened with one of our cases recently. Someone was delivering vegan chocolate chip cookies to like a pretty popular like little place that has like a franchise. And they just stopped their payment and she kept asking, she kept asking. Well, she didn't have a proper contract. But she did say, and like, okay, so one of you said, I think, Catherine, you can contact the customer, state that if a payment is not made, the cupcakes will not be delivered. Yeah, so that is true. You want to like you don't want to keep baking, right? You don't want to keep wasting your time doing your work. So you want to tell them, like, look, if I'm not getting paid, I'm going to stop the work. But now, how do you get back the money, right? As well. So in that case, even though she didn't have a written contract, she did have some emails. She did go to the store, and it turned out the manager loved the cupcakes, and so did the other employees. I mean, her case, it was vegan cookies. So, she has some witnesses. She had like some invoices that she had given them in the past. She had got some payments like through her bank account for them. So she could use that as proof. And eventually, we can say, hey, we've got all this proof, so you guys need to pay. And she can take them to like small claims court, for example, right? Or to regular court. Um, and then in terms of like, do you have the right to terminate it? Yes, right? Like Catherine mentioned, you can terminate it if they don't pay. Okay, next slide, please. So these are the tips is always, always, always put things in writing. Okay. So I don't care what kind of business you have. It's nonprofit, it's yourself, it's any type of restaurant or any type of business you have, always put things in writing. For example, let's say you guys agree to something. Like I had a Taekwondo company one time that basically during COVID decided to sell like one of their spaces and they wanted to sell the van where they transport the students for like after school activities. So they never really put down like, does it include like the furniture inside the office? Does it include the after school books? Like it was just kind of like they scribbled something down. So you want to always, if you ever end up in a situation where, maybe you're out in the middle of like your car breaks down outside of Bakersfield or something and you try to buy another car, like just write it down in your phone, like send a text message, say, please confirm this, that you received this text, that this is our agreement. Don't transfer over money or a lot of services without getting a confirmation in writing. Other thing is, a lot of people sometimes break their phone, and it's not that easy to go and get back your text messages all the time. So if it was me, and it's something really important, and you have it in a text or you have it like maybe you wrote down a contract, take a picture of it and send it to your email. That way you always have a backup copy. And this also goes for commercial landlords. Like if you rent a space and the landlord promised to fix your roof, we'll put it in writing and then send it to your email. Be specific, protect your business, and think ahead. Okay, next slide, please. Like we mentioned, oral art agreements, they could be binding, but they're difficult to enforce. A written agreement is less risky and it avoids any, the rights and avoids any confusion about who's supposed to do what, which day are they supposed to deliver something, how much work are they supposed to do. So obviously, that's important. And also the person who's drafting the agreement, like let's say you're the one who's putting together the agreement. If there's ever confusion about it, the court's going to say that we're going to interpret it against you because you were the one who's drafting it. So, if you meant to sell these yoga mats for $10,000, but you put $1,000, well, we're not going to believe you because you're the one who wrote the contract. So, if you wanted to, you could have put $10,000. So, the zero wasn't missing. So just remember the person writing it has to be extra careful. Okay, next slide, please. Yeah, it doesn't have to be a complex agreement. A lot of people are now using ChatGPT or some kind of AI or something, or maybe just simple sentences. That's okay. You can do that. But obviously, if you have the opportunity and you're entering into a contract for like renting a space for a year or two, or some kind of services, just call our office. You guys may forget to add certain things, and um we can help you like add certain things that maybe even the AI didn't think of. And we can try to just make sure all your bases are covered. And Catherine mentioned, I think it's Luis Mayer who said oral contracts aren't worth the paper they are written on. That is probably true. And maybe back then the paper was more expensive than it is now. Um, and then number paragraphs with clear headings. Yeah, so it's easy. You can just say like, okay, here are the remedies, here's the courts, here's the amount, right? You can like he put a heading for everything. Next slide, please. Okay, so in terms of the details, talk to the decision makers, make sure the person with whom you're negotiating has the authority to bind the business, right? So let's say that guy was going to sell his Taekwondo studio. What if he's just the manager and he's selling it to somebody and the owner doesn't even know about it? Like we've actually seen stuff like this. So, does that person that you're having a contract with, do they have the right to you know, represent the company, especially if it's like a very big thing. You could say, like, you could require, like, maybe you're talking to the manager and you say, oh, we require that the owner also signs this. So I think that would keep you a little bit more safe. Um, or that you write down that, yes, I'm the manager, I have authority to enter this contract. And then identify the parties correctly. I mean, another thing too, just on that last point is like sometimes maybe there's like two or three partners in the business, right? So you just want to make sure like, are you just entering with one of them? What if they get into a fight? So, and what if they just sign their name? Like they just say, "Oh yeah, we're gonna sell you this old pizza maker," but they don't actually maybe they're not going to work there anymore, right? So you want to make sure that they actually represent the company. They're not just signing it on their own, like, okay, me, John Smith, I'm agreeing. Instead, you want it to be, no, like, I'm John Smith and I work for X company, and X company is agreeing to give you this pizza equipment. Um, Identify the parties correctly. One thing you should always do, I think, is like when you're doing a contract, though, of course, public counsel, we can help you with it. It's always a good idea to, at that point, get the other party's full information. You know how, like, when you get in a car accident, I mean, God forbid, but if you ever have a car accident, you are like, okay, can I see your driver's license, right? So you see, like, can I have your phone number? Can I have your insurance? So similarly, when you're doing a contract, like, you don't want this guy's name to just be John Smith. What if he disappears and you can't find him on the internet because there's 2,000 John Smiths, right? So instead, you're like, okay, John, like, what's your address, right? Like, what's your phone number? What's your email address? And put it in the contract because if you ever lose him, now you can try to find this guy on social media, or you could, he doesn't deliver you this thing that you ordered. Well, you can find him somehow. Um, let's see. Include all the details. Judges may only look at the four corners. So put everything you can think of in that contract. Like if you're also selling the car, as part of that Taekwondo studio, then put that the van, the student's van is also included in the sale. This was a Honda. It's worth $20,000. It's a 2009 car. Like, make sure that it's all included so they don't later say like, oh, I wasn't going to sell you the car as part of this sale, Um, do not leave out any details. if you forget something, you can create a short amendment. So, you could, and I think that's why it's good to be on good terms with people because once they're mad at you or something, it's going to be hard to say like, hey, you know what? We forgot to add this little thing, right? So you can, if you go home and you realize, oh shoot, I forgot to put in the price of this. Well, you can say, hey, we forgot this. And at the very least, you could send an email to them, right? And say, oh, or a text or something. But it'd be better, of course, if you do a formal amendment and you both sign it, but at least get something in writing. Um, Next slide, please. I think we're getting towards the end. Oh yeah, and let me see what Catherine wrote. My clients were the LLC managers. The wife of the friend signed a contract to buy 800 a month in advertising at a movie theater. Oh. Because this woman was not a manager of the LLC, the clients were able to get out of the contract. Oh, interesting. So she wasn't the manager. Yeah, see, that's kind of interesting. Like if you don't represent the company, you can get out. That's a good example. Um, Be specific. Okay. So what do you want to have in the contract? Do you want to know who pays who? When should the payments be made? You don't want someone to say like, "Oh, I thought we're going to pay you at the end of the year after we already got all the milk from you for the year for the ice cream shop," right? It's like, "No, we want the payment every Friday, right, when we deliver the milk." Um, what are the conditions for making the payments? Maybe, the condition is that you have to do some work, right? And then like for your yoga class, like I go to class and then I pay for the class after the class is over. Does any work need to be done beforehand? Does payment depend on one party's satisfaction? Um, like this could be like, sometimes like it needs to be like you are, I don't know, maybe you're remodeling a home or something, right? And does it have to be based on the satisfaction or is it just like, oh, well, we already did it. Hope you like it. Thanks, bye, right? Or maybe if you're ordering the service, you could say, like, we're ordering the service from you, but we want to make sure it's done to our satisfaction or at least a reasonable standard, right? So that they don't totally mess up your house or mess up whatever they're working on. And are the payments made in installments or all at once? So again, how often do you want to get paid? And it's also a good idea to even say like the payment should be made to my Zelle account. Here's my Zelle information or here's my bank information. Here's where you deliver the check. Because later they could say like, oh, we just didn't know where to pay you. So it's like, no, it's right there. Everything's clear. Next one, please. So in terms of protecting your business, basically, so sometimes if you guys are dealing with something that's more protected, like confidentiality, so this happens a lot. You want that in the contract. This is sensitive information. You cannot disclose this. So where do you see that? You see it with things like, let's say Coca-Cola, right? Coca-Cola probably, contracts for a bunch of its ingredients or whatever, like for kitchens. Well, obviously, nobody knows the ingredients of Coca-Cola, right? No one, for like 100 years, no one's been able to find out how do we copy Coke, right? It's very hard because they have very strong confidentiality clauses and probably only a couple people know the ingredients. Um, Similarly, like client lists, like we have a client recently where this guy worked for this company that was I forgot, some kind of tech company, but they do accounting, sorry, they're an accounting company and they have a lot of client lists of all their clients. Well, this guy went and joined another company and, the second company in California. And now the old company is like, well, you signed an NDA. You're not supposed to use our client list. And the day before you left and quit our job, we noticed that you accessed the client lists. And so they're telling him, like, well, they're suing him right now, actually, and it's going to cost his company a lot of money. But, he in that kind of case, like if you're someone that has like very important, maybe you've spent like 10 years trying to develop something or, trademark something, or you have all these important client customer lists and you want to make sure they don't steal it, then have them sign something that says this is confidential, right? You guys are not going to be replicating this or using this in another business or whatever. And be careful about how much you're giving, access to that information. Um, Terminating the contract, you could identify the circumstances when one party can just end the contract. Like if you miss too many deadlines or you miss the payment, right? Can you just end the contract? Like usually you can. Okay, next slide. Okay, so thinking ahead, sorry, give me one second. Sorry. Yeah, so in terms of like you want to, okay, so one of the things, so now we've obviously talked about like, be specific, figure out like how you can get out of the contract, how you could get paid. We've talked about all this, the stuff that you need in a contract. Now you have to think what happens if both of you guys get in a fight and now, the contract's ending and everybody's angry, like how are we going to resolve our dispute? So, you could put in there, some people say we only want arbitration, right? Like when you go to the doctor's office, you know how he normally says like you're signing off to arbitration. Sometimes they say like, oh, there should be mediation. So, what I usually suggest, in this type of situation is that if it's a small issue, like it's, just for like those yoga mats for $1,000, right, that don't get delivered, well, you can just go to small claims, right? So if you have a small business and you're not an LLC, you can sue for up to $12,500. So what we tell people is even if you have a contract and the other party owes you 20 or even $30,000, just go to small claims because it's going to take you just 3, 4 weeks and you get your trial date and you get, a judgment. But if you go to like a regular court, it's very complex. It could take you 2 years. You're going to need attorneys. And let's say you get your 20 or $30,000 judgment in your favor. Well, how do you go and collect it, right? So sometimes when it's like a smaller amount, and I would say anything under 20 or 30,000, I would say the best bet is to go to small claims. If you're an LLC, you're unfortunately limited to only getting up to 6,250 in small claims. But sometimes, that's still enough. Um, in terms of arbitration, like, okay, yeah, so Catherine put trade secrets. Yes, it could be a client list. It could be a process or a technique. That is very true. Like how do you make this special ice cream or something, right? Or milkshake. Maybe there's some special ingredient. Um, it should be protected. The difference between mediation and arbitration. Okay, so arbitration, now some people prefer it, like a lot of big companies, like those doctors' offices. I think the reason they prefer it is because it's a lot faster and you don't have a jury trial. And if you think about it, a lot of doctors and stuff in the hospitals, they don't want a jury. They don't want like a Los Angeles jury to go against them. So an arbitrator is just usually like one person. And it's not like a jury of Los Angeles residents. And they may not want such big awards against them. Arbitration, though, the negative is that you can't appeal it. So once you get into arbitration, if you don't like the decision and it goes against you, you're stuck with it. Like you can't appeal it. The other thing too is yeah, it basically saves you like a lot of time. It saves you a lot of money to go through arbitration. But what I think is the best thing to have in there is maybe not even mention the arbitration, but just to say like before you resolve it, before the parties go to any type of tribunal, right? Any type of court, any type of arbitration, that we are engaging first in a mediation. And that the mediation can be on Zoom or it can be online. And that way, like, even if you're in a different state or city, you could just do it from your home, right? You could get on your computer for 4 hours and see if you guys can realistically resolve this without going to court or arbitration. And mediation often does work. You could also require that you go to like a mediation you pay for, or you could go to mediation that is just between the parties. And we also have like a list of nonprofit mediators. So if some of you can't afford like the mediator fees, which could be like $200, $300, $400 an hour, um, we can also like suggest to you guys some of the mediation. Even the county of LA has some mediation services. So it'll be a lot cheaper for you. So if you think about it, attorneys now cost like $500 an hour, sometimes more, sometimes 400. You know, I've seen crazy charges for attorneys right now. Um, so if you can go to a mediation first, well, hey, maybe you save like $10,000 on attorney fees, and that's kind of worth it. So put that in your contract. The other thing is governing law. Okay, what state, because you're going to be in your business, you might be dealing with like a computer, like some tech company from another state, and then you're dealing with like a vendor from another state. So you don't want that person to sue you and say, well, now you have to come to Texas to court, right? So to avoid that cost, you can say like, we're only going to apply governing law is going to be California law. And the choice of forum or where we're going to also decide to do our lawsuit is also going to be in California and it's going to be in Los Angeles, right? That way you can make sure you're not going to San Diego or something. Next slide, please. Sorry, I had to drink some water because I've been talking a lot. Um, okay, final words of wisdom. So check with your attorney before taking any important steps, contract drafting, negotiation, and enforcement. Um, Remember, like when you do talk to an attorney, there is something called attorney-client privilege. So normally the attorney cannot go tell the other party or go to the judge and just say, hey, this is what my client just admitted. So it's better to be honest with your attorney, um, you know, and then, prevent litigation whenever po possible. So if, um, if like there's an ambiguity or confusion between in your deal, try to like resolve it in an amicable way. Try to just talk to the guy or the girl on the phone. Try to see what you guys can do so you don't end up in court. Because once you guys start like a litigation, like once it actually goes to a court, sometimes people's egos gets involved, right? And it could be like we've seen cases where somebody spent like 50,000 on the attorney and it took 2 years. And at the end, the guy's like, well, maybe I should have just used some of this money to just settle, like give them 20,000, not pay all these attorneys and we could have resolved it within the community, right? Sometimes the community is actually a very good resource for you if it's like someone who knows them or like you or again you go through a mediation that's again like using almost like a community source. Also, like if you call us at public counsel, we can probably help you like review your contract, draft your contract. If you get into like an argument or like a dispute with someone on the other side, we might be able to call them and like try to resolve it for you guys, right? So before you spend your money on the attorneys, or you get into a big contract issue, you may as well send us your contract draft or say, hey, I need a contract for X and Y. Let's see if we could help you, look at it or help you write it. So just keep our number. I don't know if it was on the first page or something. Maybe Courtney, you could put that back. And then, so if you get a chance, keep our number as like free legal help or something in your phone. Because if you have an issue that comes up, oh, sorry, I think it's like the third, yeah, this one at the bottom. Like you could keep that phone number or you could write down like public counsel, like free legal help because most because you guys have businesses like nonprofits or small businesses, most attorneys are going to charge you a minimal of $10,000 to start your case. Um, so if we're able to help you resolve something, then hey, maybe you save that money. So just keep it, you never know. But yeah, any questions? Don't know. I guess not.
Yeah,
But
thank
yeah,
you for that, Courtney and Kavita. Yeah, we do a few minutes for questions. If anyone has, you can put them in the chat, or if you raise your hand, I can mute you if you'd like. Um, so yeah, just leave it open for a few minutes. Okay, hold on. Jessica, I can unmute you. Okay, Jessica, you should be able to unmute yourself now. Jessica, are you there?
Okay. Can you hear me?
Yeah, I can hear you now.
Okay. I have a question. As someone had mentioned earlier in the chat, that like laws that govern the area where you in would void certain things in a contract. Where can you find those laws?
Sorry, did you say certain where you void certain things in the contract? Is that what you said? Hold on, let me check what the chat says. Um, can you tell me again, like what example you were saying from the chat? I'm not seeing it. Oh, are you talking about the one where it says that you don't guarantee the results? Like, uh, I see that question that I did not answer. Is that the one you meant, or sorry, Jessica?
Yes, I can
Yeah,
unmute.
sorry. Can you repeat? Oh, sorry, you were on mute. Yeah, can you repeat that question?
Okay. Can you hear me? I don't
Yes.
see a way that you can hear me.
Yeah, I could hear you.
Oh, okay. What I was saying is like, for example, if I had a lease and I rented a place and I put in the contract that the rent will increase 20% each year, but I'm in an area where they say the rent can only increase 10%. Where do you find those
Okay.
laws so that you don't make
Oh, okay,
because
okay.
that one would the government law would take over, so my that part of my contract would be void. But I want to know like where you can go and see those laws that in certain areas.
Okay. Yeah. Well, I mean, in California generally, you can only increase. Well, is this a residential or commercial property?
Um, the reason why I'm asking too is that I had a contract once and the business ended up closing down because they wanted a percentage of the proceeds because it was a child care center. And the
Okay.
leasing, the people that leased the building to us wanted a percentage. So I was just curious, like where you could find those laws. I know that that's legal if you agree to it, but we didn't want to agree to the
Uh-huh.
higher amount. So the only alternative was to close the business.
Oh, I see. Let's see. So, I mean, 20%, yeah, so it looks like in California, I mean, see, the problem is like commercial tenants don't have very many rights, to be honest, compared to residential tenants. So you guys don't have that cap, like they can increase your rent 20, 30% if you agree to it. But they do have to give you certain notice. It depends, like, how much notice they gave you. Um, and also with a percentage, like, can they take a percentage of your profits? It looks like it may be possible if you guys agreed to that, because that's the whole freedom of contract thing. Um, But if you want to look up laws on that, you could, I think we would need to look a little bit more at your contract just to double check because once in a while there may be an exception. So if you can, I guess we could either take your, if you could put your information in the chat, we can have someone reach out to you, or you could call us at the number that's on the screen, and then we can have an intake with you and like look over your lease. I don't know. Courtney, do you have anything to add on there?
Nothing specifically to add, but if it's like a more general, like a general conceptual level, like if you're just concerned with, what laws your specific city might have about things or the state in general, like you can do quick Google searches too, just to, like indicate what the problem is that you're wanting to, that you have the question about, like what laws relate to commercial tenants in that specific city where you live. You can try to do searches like that. I'm not sure if that answers the broader question of just how you find what laws are applicable to you depending on where you live. And to include in the contract or make sure that the contract complies with those laws. Not sure if I maybe misunderstood the question, but from what I thought you were saying, Jessica, maybe that could be helpful too. But like Kavitha was saying, if you have specific questions for us, the number again is on the screen, and so is the link to apply for services.
Yeah, but Jessica, I'm glad you got, I mean, it looks like that was not a good landlord because you have to shut down your business and they're trying to charge you a percentage. So that seemed kind of like difficult. But yeah, I did write down your email address. So Catherine asked if you're working with a freelancer, um, yeah. Oh, yeah. And Jessica, we do have your email address, so I will give it to my intake person to reach out to you. And then Catherine said, if you're working with a freelancer, can you put in the contract that the copyright for the work created for you is transferred to you and you can copyright the content? Yeah, I have seen that before where like anything, like you're hiring someone and you want to make sure anything created for the project belongs to you. There is specific wording that people put for that. You could, if you want to, if you're working on a contract right now, we could like have someone like review that for you. If you want us to reach out to you, Catherine. You could put your email in the chat and I can see if somebody can contact you. Okay.
Okay, well, I think we're about out of time. Yeah, if anyone else has any other questions, like they said, feel free to reach out to them. They are there as a resource. And just want to say thank you to everybody for coming today. And of course, thank you to Courtney and Kavitha for presenting. Just a reminder, when you exit, there's a survey. If you could fill it out, that would be great.